This podcast is sponsored by Murgitroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgitroyd.com/podcasts.
Hello and welcome to the 5th season of Murgitroyd's Innovation Talks podcasts. We're delighted you have joined us. If you have any questions, you can email us at innovation.talks@murgitroyd.com or contact us via Twitter @Murgitroyd. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's podcast.
Hi, I'm Rahila Bhat. I'm a patent scientist at Murgitroyd. I work in the York office at Murgitroyd in the Chem Bio team. And I'm delighted to be joined today by Catherine Bonner. Hello, Catherine.
Hello, Ray. It's really nice to be with you today.
So Catherine is a director of patents and head of the Southampton office. And I've invited Catherine to talk today about mitigating risks during IP collaborations.
Thank you, Ray. It's really, really lovely to join you today. And I'm looking forward to talking about this fascinating subject and something that I think will be of real interest to those listening to the podcast.
Excellent. Thanks, Catherine. Let's start by defining what we mean about IP collaborations, because that's important. We've certainly seen a lot of collaborations in the past few months, and the COVID-19 pandemic has rallied a concerted and collegiate global effort to develop a cure. So teams of researchers from different enterprises are collaborating to seek solutions through computer simulations. They're repurposing existing drugs and the development of new vaccines. So we've seen many pharmaceutical companies have partnered with academics using their expertise to accelerate the search for a potential cure. So Catherine, I know you specialize in electronics and electronic inventions. What's your experience of collaboration?
Yes, I completely agree with the points you've outlined there, Ray. Really, what's been interesting over this COVID-19 pandemic, I think, is the coming together of universities, academics, and those in the industry sectors. That's been interesting across industry sectors to see that happening. In the electronics field or the mechanical inventions field, we see collaborations with universities and small companies, often, I think, to accelerate or to provide some product development, maybe initial prototyping. I've also seen collaborations between a larger company that requires some research that they don't perhaps have the capacity to prepare themselves. So outsourcing or collaborating on a point, or collaborations across sectors. So a particular skill set that's recognised and then bringing that into a company, a startup, academic institution. And sometimes those collaborations have been surprising. I think the recent work that Dyson carried out in the field of the ventilator space was really interesting to see that in a new area for them, and also others that were working in that area, Rolls-Royce and some others like that. So it's interesting working on collaborations, very interesting.
So yes, definitely. So in light of this, it is expected that there will be a surge in co-owned patent filings. Jointly owned patents carry particular risks, and I'm sure you will agree it is important to mitigate these risks where possible.
Yes, absolutely. And I think the risks, particularly I'm thinking of, are around confidentiality, particularly in the early stages.
So collaborating or working collaboratively involves sharing of information, which is not always what you want to do because you've worked quite hard in developing your invention or the idea. So what would be your advice in terms of confidentiality?
Confidentiality is really, really important. At the outset, often all the parties involved tend to be quite precious about their ideas and their focus for a collaboration, but also often really enthusiastic and really keen to get going. And I think that can be a real point of risk, where everybody's trying to work together to come up with a common solution, work for the common good, hopefully. You want it to be a productive environment. You want there to be cross-fertilization of ideas. But really, before the outset of those discussions or that collaboration, it needs to be set out who owns the initial IP, who will own the generation of the IP that's being discussed, that everything during that discussion should be under terms of confidence. The parties need to set out where they're going with the collaboration, the ownership of any IP that comes out of it, and their own desires for the result of the work. And I've seen a lot of mistakes and problems come up where that's not been ironed out very early on. And tidying it up afterwards is always trickier than setting it out at the beginning. I think you'll agree with some of your experience perhaps as well, Ray.
Yes, that's absolutely right. I mean, where I've worked previously in a startup company, it was very important to highlight to the inventors and any member of our team when reaching out to third parties to set up a collaboration or even an inquiry, because that's usually how you start this. In those instances, you must highlight the importance of either keeping an NDA in place, or if it's too early for an NDA, just keep your topic broad and generic, that you don't disclose anything which is really the crux of your invention, which is important that you want to protect. That's key and that's critical. And what can really help in these instances is to provide that information to your team, have it available. So I did find sometimes team members weren't sure what they can say and can't. Do I say this? Do I not say this? Am I giving too much away? And there was a real nervousness around this. And for that reason, just if there's a little guidance, one line.
Yeah, absolutely. I think it's important that people know why they shouldn't be letting the cat out of the bag. Everybody's really keen to get on with the project. But if you can provide some background and where we're headed, what we could do if we maintain our ownership of this burgeoning IP, and then the advantage that it provides in the marketplace, the buzz that would be around the new product or the new innovation, then yes, absolutely sharing that and sharing the journey, I think is really, really important.
I think maybe at this point as well, we could possibly highlight the reason why we want to keep it confidential, the invention, is we don't want it to anticipate our own patent that we want to file.
In order to be granted valid patent protection, the subject matter of the patent application must be new, must be novel, and that is assessed at the time of putting the patent application on file. And so any prior disclosures, be that in trade press or be that at a conference or be that outside terms of confidence before the filing date of the patent application, can completely jeopardise the hope of being granted valid patent protection and having monopoly rights to the intellectual property that has been developed. And patents are often at the key of innovation and innovators' minds. And yes, absolutely, non-confidential disclosures are not what you want before you file a patent application.
Moving forward, what is your experience of the good, the bad, and the ugly in terms of co-owning IP?
Yeah, I love that. That's great. Yes, I think co-ownership of intellectual property, it's never recommended, but perhaps sometimes it is the only way forward where there has genuinely been completely equal input into an idea and both parties agree. Then co-ownership perhaps is the only way forward. The disadvantage with co-ownership is that any use, that would be a license or any decision about the life of the intellectual property rights. In particular, I'm talking about patents here, but those decisions need to be made jointly with the co-owners. And that might be completely acceptable at the outset of the arrangement, but maybe the parties' goals and aims differ over time. And the life of a patent is 20 years. That's quite a long time in any commercial relationship. And I think that if you have a differing of opinion, it can make things more difficult in terms of navigating, maintaining, or pursuing the intellectual property rights that you are co-owning. The worst situation is when you have a disagreement like that, and then there's a fight about who owns the IP and a disagreement as to what was agreed at the outset. And that can end up in litigation or at least protracted legal proceedings and unpleasantness between the parties. I've often had experience where people have wanted to co-own IP, and then what we've been able to do is navigate through that and provide a license for one party to use the IP. They don't own it, but they have complete freedom to use the IP for their purposes, which is actually what they want at the end of the day. And we've been able to allow that and shift the responsibility, the ownership, onto the party that will be there making the decisions, paying the fees. Inventorship, we should say, is completely different to ownership. So inventors have every right to be listed on a patent application, to be named in a granted patent. And often inventors have this added to their CV, a little bit like published papers or journal articles. And inventorship is something that you can have a list of inventors from 2 or more institutions or differing parties. The ownership can be different to the list of inventors. So yes, plenty of experience, but really for patents, I would urge against co-ownership.
I guess you've also, from your experience in practice and years of experience behind you, have you ever come across such instances in your career where you've had to deal with issues between co-owners?
It's always a good exam question as well, co-ownership. And if every answer at that point should be, cross-license. But yes, yes, I have actually a couple of, one was a scaffolding company. Actually, they had a great invention, and that was just a disagreement between the inventors, and they went their separate ways, as these things happen. And the invention was owned in the name of the parties rather than the name of the company. So that didn't go so well. And another instance where it was found that the patent rights were with the inventor. They hadn't been assigned to a particular company. And then we had to move forward with that assignment when the inventor wanted to sell on the company and have investment in the company. So yes, there have been situations like that. I spent some of my professional career working for Dyson Technology Limited, and there we had very, very strict non-disclosure agreements in place for any sort of collaboration or research topic that we were working on, and really just kept IP very tightly under wraps so that was always owned by Dyson. We knew there that the IP was with the company. So the other way to do it is really just to tie up very tightly any collaboration or joint work that you're doing.
Well, with all this said, what would be your top tips for maintaining a positive collaboration?
Yes, positive collaboration and staying in communication and with clear goals throughout the collaboration. I think that's really, really important. What should come out of a positive collaboration is that all parties are recipients of mutual benefits as a result of the collaboration. That's where you're heading, really. And with a joint agreement between the 2 or more parties that are going through the collaboration. There are some standard agreements for this, which can help, particularly if collaborating with universities. And I think before the onset of any collaborative work, there needs to be definition between the parties where you are starting out, where you want to get to. I think you must have had experience of this as well, Ray.
The company where I worked before certainly collaborated with big industries who were responsible for manufacturing certain starting materials. And therefore, we did set up agreements that were watertight. Everything is agreed from the start. You do not want to have any problems or issues, but also there's a beauty in a positive collaboration, one that can last and that can benefit both parties is so important for long term. And secondly, where we've had contractors coming in who are, they can see the types of work that we are currently working on or we're investigating and that we want to protect. So always have that NDA in place, always have in place, what the IP ownership is. And we did that from the start, and an open conversation is pivotal to that.
Being open and upfront. No one likes surprises in an agreement or something that comes later down the road that you wish you had known about initially. Completely agree. Costs, I think, are really, really important. So in any IP collaboration, ahead of the collaborative work, I think it would be key. I would point out that these are the key items that should be agreed. The cost of IP protection, particularly patent applications and patent prosecution, would be very, very expensive, and that needs to be ironed out at the beginning. And then also the decision-making process during the patent prosecution, who is working with the patent attorney, who is going to provide the instructions. It's always nice to know who we're emailing, but also so the parties are aware of that decision-making flow, where they're inputting their comments, where their comments are not required, things like that. And then later, once achieving patent grant, if the collaboration is still at that point, then really licenses, assignments, any mortgages, registering any interest in the patent, particularly for fundraising purposes or investment, all of those decision-making processes need to be set out so that the parties to the collaboration feel involved. I think that's really important. And gosh, more costs I'm talking about now. But yeah, maintaining the patents, that means renewal fees. Life of a patent, as you know, 20 years from the application date. And that is only in force, and those exclusive monopoly rights are only there for the collaborative team as long as the renewal fees are paid. So they really need to be agreed upfront who's paying those. And then should the patent rights need to be enforced? So that would be against someone who was perhaps infringing or was deemed to be a risk. Then the enforcement of those IP rights and the costs associated there, that should also be set out clearly. As you were alluding to earlier, that were in your agreements, any forum for resolving issues during the process or resolving disputes, the forum and the management of those disputes should also, I think, be set out at the start. You don't want to be in the middle of a disagreement trying to find out how you should be proceeding or feeling your way. As you said earlier, setting everything out from the get-go so it's clear, the parties know the plan. I think that's really what can make for a positive collaboration experience, and I'm sure has been used over this COVID pandemic period in all of the collaborations that we've seen, and that the marvellous working together and coming together.
It's very true. Just one question from me that I thought of is, during collaborations that you set up, for instance, if you have somebody who's manufacturing something and that's in relation to your invention, it isn't always that you as a company would own the whole of that IP. You can separate the IP ownership to different sections, isn't it, based on your contribution?
Yes, and that can be decided by a percentage. I often see that in university collaborations. The universities are often very keen to understand the percentage of the contribution that comes from each inventor group, really with cross-collaboration or cross-departmental collaboration. Also, companies where they have some sort of inventor recognition or reward scheme. That's really, really important. Individual companies can decide to have an invention reward scheme or not. It's not set in statute, but if there is a reward scheme, it's really crucial to record who's done what, and a percentage assessment can be useful there. So yes, throughout the life of the collaboration, being clear about who owns what and how you have compartmentalized that for particular examples that you've said there, that's really important. I absolutely agree.
Well, thank you very much, Catherine. It has been lovely speaking to you about how to mitigate risks in IP collaborations, and really interesting to hear your insight. And I look forward to speaking again soon.
Well, thanks, Ray. The pleasure was all mine. We'll speak again soon.
Thank you.
Thanks for your time today. We hope you found today's podcast valuable. And remember to subscribe so you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgitroyd.com.